being regulated at the state level. This bill provides the regulatory stability and certainty that enables business owners to expand their businesses to other cities within Texas with more consistency, creating more jobs and prosperity in the process. At the same time, it actually gives local governments a hand by giving them a simple reason why they won't, in fact, be bringing a vote to countless issues that activists have been harassing them to pass locally. This not only saves money in the budgets of local governments, but also gives them back a measure along with the freedom to focus on traditional local issues they're equipped with to handle. Texas' economy relies on businesses and industries that cross local government boundaries. They often have more than one location. They service customers in many locations, and their employees work in different locations and across boundaries commuting to work. For example, you may have a restaurant owner with 2 restaurants in the same area, but on different sides of a city limit line. There could be a landscaping company, a general contractor, a plumber, or an electrician, all operating within the same area, but dealing with different regulations. We want those small business owners creating new jobs and providing for their families, not trying to navigate a Byzantine array of local regulations that twist and turn every time they cross city limit sign. The bill also positions Texas to capitalize on the rebounding growth of stateside manufacturing as the onshoring trend causes businesses to move away from geopolitical hostiles like China and back to the U.S. soil. As that opportunity looms larger, why would anyone want a company to go to the trouble of building multiple factories and multiple TAMs with the complexities of a disparate rules promised to fill their shops with inspectors and drain their wallets with fines and fees? A statewide standard is far better. Much has been made about the historical role of what a home rule cities are. They are a creation of the state and enshrined in the Texas Constitution. When they were created, they were given limitations despite some popular rhetoric. One of the most important limitations is in Article 11, Section 5 of the Texas Constitution, which provides no charter or any ordinance passed under said charter shall contain any provision inconsistent with the Constitution of the state or the general laws enacted by the legislature of this state. House Bill 2120 simply gives full force and effect to that provision of the Texas Constitution. My first few sessions, we had to deal with 1 or 2 preemption bills. This session, because of where cities have been, we've had multiple over and over and over again. Some specific examples: paid sick leave, where we've had Austin, Dallas, and San Antonio enact ordinances that were proposed during an election cycle. Dallas bank requirements. Dallas now requiring banks vying for city tax dollars to report investment lending deals. The Austin DCLAW ordinance, passed pretty much secretly in March 2021 during the pandemic, creates a violation if you declaw a cat. Overtime fairness, allowing, basically saying workers can decline overtime without penalty from an employer. Fair chance hiring, making sure no criminal background checks. And those are just the ones we know about in Texas today. Let's talk about the ones that are coming now from a neighboring state. Pay transparency would require employers to disclose pay range as well as benefits, not only to applicants, but for internal offerings and promotions as well. Salary history restrictions, preventing employers from asking applicants how much they make at previous jobs. Predictive scheduling, requiring employers to provide work schedules to employees in advance, usually 2 weeks. Prohibiting criminal background checks by employers. Paid COVID leave, paid sick leave, requiring private employers provide health insurance at $380 a week. Eliminating at-will employment. Denver requiring not allowing anything but cage-free eggs to be sold. Now, members, cities will retain a lot of power under this bill. One of the things that there is, they still get to have full zoning, unrestricted. They can still deal with unrestrained animals, hawkers, peddlers, pawnbrokers, billboards and other outdoor signs, nuisance, disorderly conduct, vehicle wrecking, daycare centers, massage parlors, game rooms, sexually oriented business, historic preservation, public safety, community planning and development, water utilities, parking and transportation, and a host of others. Those are just a few of the things people have said this bill takes away. Clearly they do not. They're still being preserved in statute. So with that, I'll be happy to answer any questions.
Mr. Turner, for what purpose?
The gentleman yield for some questions.
The gentleman yield for questions.
Of course.
Gentleman yields.
Thank you, Chairman Burrows. So there's been some concerns raised about the broad nature of this bill. There could be unintended consequences with several different areas of the state statute in play in this bill. So I think you spoke to your intent with the legislation in your layout, but let me just ask you very simply, if your bill passes on day one of its enactment, what's going to be preempted? in the state of Texas today?
Well, the 5 ordinances that I laid out, and also I have some amendments that I think will take care of a couple others, like some climate change stuff in El Paso. But obviously, the ones that I laid out in there would obviously be preempted. In many of the ordinances that you brought up and others have brought to my attention, clearly would not. We were able to show in section and verse of local government codes and other places where those authorities remain.
Okay, so you mentioned something about declawing cats and. I think you should have paid sick leave, which I think the courts have already set aside. So I don't think that's an active issue anymore.
Dallas bank requirement, fair chance hiring, overtime fairness. I mean, things of that nature.
Okay, is that all it would preempt?
So there's a host of things that preempts. Those are the examples I have right here to visit with you about.
Okay, so you don't have a comprehensive list?
I'm sure the list, as I continue to look at it, there's a lot of them, but I mean, I've laid out the ones that we can talk about right now.
Okay, those are the ones you want to talk about right now. Okay, so you mentioned that current home rule cities still have the power of general law cities. How big are general law cities?
So by the way, the reason I put that in the bill was because I actually sat down and met with the city attorneys and others from TML, and they wanted to make sure that they had at least as much authority as general law cities, and so we gave them that provision to satisfy some of their concerns.
Right, and how big are general law cities?
I believe the number's 5,000 in there, but that was something they asked for, not something we did to them.
Okay. Understood. So 5,000 people or less is a general law city.
Yeah.
5,000 people or more than 5,000 people is a home rule city. Is that right?
If they go through the proper proceedings,
Sure.
to actually do that, and I've never done that, so I'm not 100% familiar. But I would also again point out what the Texas Constitution does say, that even a home rule city cannot pass any ordinance in contravention to the general laws of this state.
Okay. So I think hopefully we could agree that a city of say 5,000 people or 6,000 people has very different needs and challenges than say a city of 2 million people.
And home rule cities will still be home rule cities after this, being able to do a host and variety of things.
Okay. So one of the things that a lot of home rule cities do and have done is they put issues before the voters to decide how to enact a certain policy or whether to enact a certain policy. How does your bill affect the ability of citizens to be able to make their voices heard at the ballot box on a matter of concern within their local community?
Representative Turner, they can still do that unless we currently regulate it. This basically just says no double regulation. So unless we have a regulatory scheme, which would be marked by having a regulatory agency or a set of laws in the books that seem comprehensive in nature, they can still do those types of things. If we actually regulate it, they cannot contravene those laws.
So if the state regulates it, and I'm going to ask you about that in a second because I think it's unclear to a lot of us still in the bill what exactly would be preempted here. But if the state regulates it, it's therefore preempted. Therefore, even the voters wouldn't have the ability to weigh in and adopt a local policy that suits their community's needs. Is that right?
And by the way, there's actually preemption language in the Constitution, so it's not unlimited to begin with. That's the point I really want to stress.
I understand, but right now we're just talking about your bill.
But
right?
this bill just broadens it ever so slightly.
So what happens if, in the course of preempting so many different areas of statute, what happens if a city, a county, a local community has an urgent need that needs to be addressed when the legislature is not in session? Because they're preempted from acting until the legislature comes in and passes a law to address that need under your bill, right? Isn't that what happens?
Most of the examples people gave in that area, they can still do. However, that's the beauty of having a court system to actually deal with this and actually, help it. I mean, the third branch of government is an important branch of government to basically deal with some of this as well.
So is it conceivable that because of this bill, the legislature is going to be called on to go into special session to address needs and say the city of Houston or the city of Temple or city of Waco to address some acute need that comes up that can't wait 18 months to be addressed?
I don't see that happening.
You don't see that happening?
Not at all.
So let me ask you about the standing section of the bill in terms. So your bill sets up a regime where basically people can sue if they think that the statute's being violated
They can already sue under the current Declaratory Judgment Act. I want to make sure that's very clear. There currently provides law where you have standing to do this.
So how does your bill differ from current law or current practice?
So we take the court rulings on waiver of immunity and we codify it. And then I've got a perfecting amendment to narrow the venue down to actually mimic what the current venue provisions are.
I'm sorry, clarifying amendment to do what?
To limit the venue to being the actual county where it occurred rather than a contiguous county. So the bill will basically be modeled after the current existing cause of action available to anybody to sue under preemption.
Okay. So when your amendment is adopted, presuming it is, then someone can sue, but within the same county that the alleged violation has occurred.
The same standing as they have today.
Understood. Okay. So do you feel like your bill will have the possible, I'm sure, unintended consequence of creating excessive litigation in this area?
Are you concerned about excessive litigation?
I am.
Okay. So I think it's actually a brilliant way to handle this because we're not here all the time and we can't continue to play whack-a-mole. So we're going to allow the courts to actually continue to help us and regulate this. And it's going to give citizens the ability and right to petition their court system to get redress of some of these ordinances which are overreaching and difficult for them.
You don't think this will spawn a cottage industry of lawsuits around this legislation?
There's no damages available, so there's really not an incentive for anybody to actually want to do this.
So, on the issue of standing, your bill talks about says any person who has sustained an injury, in fact, actual or threatened, has standing. Did I quote that correctly?
That's the common law, traditional American court system of standing. I basically took that and put it in there, which is the standing we use for negligence suits and a lot of other things that we currently do. So it's not new or unique. It's kind of within the American tradition of standing.
Okay. So how does someone prove a threatened injury?
Well, obviously an ordinance passes and it could potentially harm them. For instance, we've had ordinances passed that have a fine attached to them, but cities have known they're unconstitutional, and so they don't actually impose the fine. Therefore, some people have actually been kicked out of courts because the fine hasn't happened. But the threat of it ought to be enough to actually have your rights litigated in a court of law.
So I'm going to move into areas specifically, and you touched on some of this, but local rules or ordinances that are designed to protect safety and enhance safety in the workplace. And so you mentioned paid sick leave ordinances, I believe, as an example of local overreach, I think is how you phrased it.
Yeah.
Did any of those ordinances actually go into effect?
No, but a lot of people spent a lot of money, businesses, and they had to comply with them for the time being before they got court certainty of it. So there was a real cost and expense associated with passing those.
So even though those are not in effect and they actually were overturned before they went into effect, you're saying that businesses say that it cost them money?
Sure, they had to try to figure out how to comply with them. Some of them actually had to hire lawyers to challenge them. It was a real, effect on there. And of course, I didn't even mention this bill will pick up, some of the workplace safety standards, and I'm sure you want to talk about those as well.
Well, I do. That's my very next topic, in fact. So
good.
So, are you aware, and I'm sure you are, because we've talked about on this floor before, that Texas construction workers are at particular risk of heat-related illnesses, injury, and in some cases even death?
Absolutely. I totally agree with you, which is why I've always believed that the OSHA, standards dealing with this are important, and most of the contractors that I've had the pleasure of knowing probably far exceed those on a daily basis.
So, do you know that the Texas Department of Insurance has provided data that shows at least 5 Texans have died from heat-related illness? That was just in 2018, and hundreds of Texans have suffered from job-related heat elements that interfere with their ability to work.
Yeah, I would argue not having proper tie-offs and being too high probably has more deaths. I don't know that, but if we're talking about construction accidents altogether, there's multiple threats out there that are available in workplace safety concerns.
You would agree that exposure to heat for prolonged periods of time is one of those threats?
Oh, sure. Yes, absolutely.
And you would agree that dehydration is such a threat?
We totally agree on that.
Okay. And so, despite those recommendations and some OSHA guidelines, and you referenced those a minute ago, that provide that rest and water breaks are a safety concern and are needed, particularly in certain types of job environments. I mean, are you aware that, and even despite a couple of cities out of our hundreds of cities having ordinances on this matter, that many workers simply do not get those types of breaks during the day?
I'm not aware of the prevalence of that.
Can you repeat that? I couldn't hear you.
I'm not aware of the prevalence of workers being denied, their rights to rest and water breaks.
Would you agree that it probably does happen? I mean, because right now, if they're not in those two cities you mentioned, they actually don't have a right.
In full candor, right? I mean, from a concept, sure, I can agree there may be that happening out there, but on a first-hand account, I have never had a injured worker, or contractor who's had one come to see me over those particular concerns. So I'm just not aware firsthand of that having happened.
So, in fact, are you aware that there is a University of Texas survey that found more than a third of construction workers in the state do not receive regular rest breaks?
Not aware of it, not aware of the survey, the metrics, things like that. Sounds like OSHA is not doing its job, and I know there's anonymous hotline reporting, things of that nature. Maybe one of the things we need to do is make sure workers know they can have a report to OSHA without fear of any retaliation by statute when those things actually occur. And I would work with you on that in a heartbeat.
Okay. So, well, you say OSHA is not doing its job, and OSHA has recommendations, not a rule, but they do have recommendations. But ultimately, it is up to, Texas doesn't typically wait on Washington to solve our problems for us. So we pride ourselves in solving our problems ourselves, do we not?
We tend to like to.
Yeah, so why would it, and if the state has not solved this problem, and the legislature has not to date, then why is it a problem for individual cities to say, this is a concern in our community? We've seen people get sick. We've seen people go to the hospital from dehydration. We've seen, in some instances, people die
but Representative,
from heat stroke.
I would point
they
out
want to solve that problem. Why should we interfere in their ability to protect those workers?
Well, I would point out to you, I think OSHA, I've only read the rest and water break bulletin a couple of times, but they don't actually have specificity on how to do, what the number of times it needs to, because it probably changes. And we both would agree that OSHA is probably the most comprehensive agency looking at these things. What I think is at issue is the cities have come up with a metric which really doesn't work and probably is woefully inadequate by even OSHA standards of a rest break every 10 minutes, every 4 hours. But they should not be the ones in the business of enforcing it. OSHA's out there. OSHA's looked at this. They have declined to adopt a similar standard, probably for the challenges of it.
Right. And in Texas, are you aware that we do not have a statewide agency that has the responsibility or the authority to enforce workplace safety standards? Are you aware of that?
So I believe that to be accurate. And obviously, if we need to talk about having, concurrent jurisdiction because OSHA is inadequately equipped, which I'm not saying I agree with, I'm happy to have that conversation. But it should never go to these cities on doing that. What I hear you saying is, perhaps you think OSHA is inadequate. I have not been led to believe that.
So let me go back to something you said at the very beginning. You claimed your legislation would help cities, I think you said, refocus on their primary responsibilities.
Absolutely.
Or something to that effect. In your mind, in your view, what is a city's or a local government's appropriate responsibility? What is their role in our governmental system?
As we look outside and we see streets and keeping them clean and making sure we have water and sewer and utilities and a police force and fire and things of that nature. And I don't have a comprehensive
list. Why are
list.
police and fire, just to pick two examples, why are those important?
Because it's something they have historically done, and we expect them.
Well, cities have done a lot of things historically that I think are about to be preempted under your bill.
I think
so. Why police and fire? Why sewer? Why water?
Your definition of historically done and mine are probably very different. This seems to be a recent adventure in foray into these areas by cities and continues to be growing. Historically speaking, when we think about what the core functions are, it's not basically having their own set of railroad commissions and labor codes and things of that nature. And obviously, they're venturing into it, and that's not something you think of traditional cities as part of what they do.
So, with respect to police and fire, that's important because
we expect when something bad happens or we need them, they are there.
Okay, because it's a matter of public safety, is that right?
which is preserved under my bill.
Right, and I would agree with you, that's very important to preserve. I would also argue that a rest break and a water break every 4 hours in 105-degree heat is a matter of public safety. Would you not agree with that?
So 2 cities out of all of the municipalities we have these and have started to do this. I would tell you this is not historically the function of city government to do this. You know, this is where OSHA has been. If the state needs to take a look at it, happy to do that, but we do not need to have a patchwork of these ordinances across the state at every municipal level.
Well,
Gentleman's time's expired.
Mr. Speaker,
Mr. Turner, for what purpose?
move to extend the gentleman's time.
Members, you heard the motions of objection. Chair hears none, so ordered.
Thank you, Mr. Speaker. So, Chairman Burrows, you agree that police and fire, as 2 examples, are historically in a city, a local government's purview, and are important because they deal with matters of public safety. And so my question is, if a city has some level of responsibility for public safety of its residents,
Public safety versus workplace safety, don't conflate the 2 issues based on the historical
So there's a difference
things.
between workplace safety and
What
public
I
safety?
would tell you is this. I am very happy to work with you or anybody else on a bill if we can sit down and say this is not being handled by OSHA, and that we need to actually have a regulatory agency that has concurrent jurisdiction to look at workplace safety issues. I am happy to work with you on those because we all want workers protected. I do not believe municipalities need to be the ones enforcing these.
Well, I appreciate your willingness to work with us. I hope we can continue to do that this afternoon. I think that workplace safety is public safety, but we'll disagree on that for now.
Thank you.
Mr. Speaker,
Mr. Wu, for what purpose?
would the gentleman yield for questions?
Oh, the gentleman
Happy to
yield for
yield.
questions. Gentleman's happy to yield.
Thank you, Chair Burrows. I know that a lot of cities in Texas have passed, historically passed non-discrimination ordinances in relation to any number of things, including race, ethnicity, national origin, sexual orientation, veteran status, women against women, or any other religious preferences or anything like that. Would your bill, as it is drafted, preempt these type of ordinances?
The bill does not affect NDOs. If you look at the local government code under the employment section, there's actually specific authority we've already delegated there, and then we've run the traps also on fair housing. And so, protected classes, both state and federally, NDOs are not preempted by this legislation.
Okay. And another area of concern, and I know this is an area that I know our body has so far failed to act, is the issue of predatory lending. And by this I mean payday loans, title loans, auto title loans, and a lot of business practices that, in my opinion at least, prey on the very poor and most vulnerable in our society. And I know that this body, we've, despite efforts over the past decade, have largely failed to put any type of regulation in. And in response to that, many cities have put in ordinances and regulations on how many of these businesses can be in a neighborhood, what kind of, restricting some of the more unethical practices that they might have. Does this legislation that you're proposing ban future ordinances in this respect?
So it does, but I want to make sure that the record's clear as we talk about this. When I brought my bill, I heard it from a lot of constituents, and I worked with a stakeholder group who led the charge on creating these ordinances and agreed with them that I would preserve all 49 ordinances in existence, and they said this was a good position, and I intend to honor that as this moves through there. And so we did grandfather those in, one of the first amendments we changed to try to address that.
So my follow-up question on that is, because these ordinances have to be in place by a certain amount of time, if a city needs to adjust their existing ordinance that was in place prior to the deadline, would they be able to do that? Would they be able to go and tweak their existing laws to change whatever circumstances.
Anybody can amend the ordinance to bring it into compliance with this statute.
But just to be clear, for the purposes of legislative intent, if they tweak an existing law that fell under the safe harbor of this bill,
Yeah.
that would not be considered a new law.
What I would tell you is this is the language I agreed to with the stakeholder group that wanted the language in there, preserving it, and it was every and, the, and what was talked about, discussed with them, and this is what they wanted, and I agreed to it.
Okay. So I appreciate that, and again, I wasn't a part of that process, but just as purely as a way to understand the implications of this legislation.
This is it. The 49 that are in there, we're not going to basically see new ones. They're not going to be amended to address other things. The ones that are in existence stay in existence.
So again, I think the answer that you're just giving me is no. Any changes, tweaks to these laws in the future would not be acceptable.
Under this bill, I do not believe these are the 49 that stay in existence as is.
Okay.
Which is what I agreed to with the
area-
stakeholder group.
I'm sorry?
Which is what I agreed to with the stakeholder group.
Thank you. Another area of concern that cities have been dealing with is dealing with unethical puppy mills, roadside pet sellers, and other things like that I know our body has had some say in it, and we've dealt with it somewhat.
If you wait for my perfecting amendment, you will see I've grandfathered those in as well, having worked with another stakeholder group who wanted to make sure that those things were done. And I think it's the second amendment that will come up dealing with it.
And just to clarify, the amendment that you're going to offer, does it clarify the conflict with the Texas Dog and Cat Breeders Act?
What I can tell you is when it comes to issues of puppy dogs, and these issues is not really an area of policy that I work on very often by choice. Members who concern about it brought this to my attention. I asked them to work on language. I believe it's acceptable to the stakeholder groups trying to preserve the things that are in place.
All right. Thank you, Mr. Speaker.
Yeah.
Mr. Speaker,
Mr. Wu, for what purpose?
may I move to reduce the writing, all conversations and discussions on this bill and reduce it to writing and place it in the House Journal for the purposes of legislative intent.
Members heard the motion. Is there objection? Chair hears none, so ordered. Ms. Ramos, for what purpose?
Mr. Speaker, will the gentleman yield?
The gentleman yields
course.
for questions. Gentleman yields for questions.
Thank you, Chair Burrows. One of the things that's mentioned in the introduction of your bill, it references the idea of this bill is to stop a patchwork of regulations that apply consistently across the state. Is that correct?
That's absolutely. I think that's what Texans want. That's what businesses want, and it's good policy.
Okay, and in fact, it's beyond statewide, right? The reality is that the attempt to do this is a nationwide movement, correct?
I have no idea.
Okay. Are you familiar with the right-wing ALEC group, the American Legislative Exchange Council?
Yeah, I know what the name is.
Are you familiar that this American Legislative Exchange Council promotes legislation that advances corporate interests and conservative positions nationwide?
Awesome. Maybe they'll take my bill and have it a model for the entire country.
I'm sorry?
I hope they take my bill and make it a model for the entire country.
In fact, did you not take their bill and try to make it as a model in the state? Because if
No, this is not their bill. I
watching-
want to be very clear, Representative. This is not their bill. This is one I worked on with lawyers in Texas and myself and others. And my guess is they're going to take my bill and make it nationwide because it's so good and important.
Well, thank you. And I think if, our representatives here or people watching at home, if they Google ALEC model policy, they'll actually be able to find this there on their website. Are you aware of that?
Because they took my bill and used it. This gave them model policy, not the other way around.
So this ALEC priority, this priority.
No.
that
This is not an ALEC
advances
priority.
corporate-
Let's not characterize that. This is a Dustin Burrows priority bill. It is important. I worked on this bill, and Jeff Leach, you want to remind me, I worked on this bill with people here, and ALEC and others are so interested. Forbes published an article on it. People published an article on it because it's getting nationwide attention because it's that important. It is not just an issue that's affecting Texas, and they have taken this bill, and they're going to hopefully take it nationwide, and that's a good thing.
So the article that they wrote a few years ago, Stop Local Governments from Being Victims of Localized Progressive Politics, they wrote that based on your bill years ago?
You're talking about an article, not something you found on the website about my bill. I mean, this issue is pervasive. There's no doubt about that.
Correct. And
Yeah.
so when we're talking about something that you're wanting to implement in Texas, it is a movement nationwide. The idea of the local democracies and communities
Well, it's representative
choosing
government.
their representatives at the city council level, this is an attempt to stop that voice from local communities to choose their local leaders and make those local neighborhood community decisions.
We have a fundamental disagreement on civics. Now, I want to go back to the Texas Constitution. When we set up and established home rule cities, it said no city ordinance or charter can have anything that contravenes the general laws of this state. That is Texas Government 101. This bill essentially gives full force and effect to that.
Thank you, Chair
Thank you.
Burrows.
Gentleman's time's expired. Is Mr. Turner on the floor of the House? The following